Thank you for the invitation. I've been asked to speak today on dental-legal challenges, looking back, looking where we are, and looking forwards. Because of time, I thought, well, I won't spend very much on the looking back bit. It's much more interesting to look at where we are now and where we'll be going in the future. I graduated in 71, and it was shimples in those days. I don't really thought much about being sued or having complaints and stuff like that, whereas it's the first thing everybody thinks about when they graduate today. There was very little litigation against UK dentists. We were doing simple-ish dentistry, and there was less to go wrong. You know, the biggest crisis that happened was somebody's lower denture didn't work, and it doesn't cost very much to put that right. It's not the same when it's implants, when it's molar endo and stuff like that. The patients were different, I think. I think they were more tolerant, except my denture patients, less questioning, and there wasn't the blame and compensation culture that there is today in the UK. It was a very different world in which I started my practice. The GDC was so laid back, it was almost supine. There were 50 people on the GDC, and 44 of them were dentists. Not so today. It's very much the other way around today. And of course, there wasn't HTMO 105, there wasn't CQC, and the rule of the day was you didn't whistleblow. And that's all changed, and now you're encouraged to whistleblow. In fact, some people turn it into a bit of an art form. So looking back, that world was a very different world, and so it is easy for people who graduated when I did to look at today's world. And I have a son who's a dentist, he's married to a dentist, her dad's a dentist. So when we're all together, we talk about dentistry. And I usually try and get CPD for all our family gatherings, but it doesn't usually work very often. What I'm going to tell you really was born, it was coming over me about sort of 8-10 years ago that something was very different in the UK environment. The GDC started to be very different. There was a change in the Dentist Act in 2005. That was a big factor. We had no win, no fee. Lawyers came into the market in the early 2000s. That was a huge factor. And I wrote an article, those of you who are members of Dental Protection might remember the article on the left-hand side with that little triangle, and then I updated it and published it in the BDJ last April. And that was really a lot of underneath what I'm going to say today. And there are some handouts at the back of the room. I don't know if you noticed them on the way in, but there are some handouts sitting on a desk at the back of the room, including what I'm about to say. What led me into that was we did some research, and we found that dentists, particularly young dentists, are very fearful of the litigation and GDC environment. 78% of the dentists who've been investigated by the GDC said it didn't just scare them a little bit clinically, but it had an effect on their mental and physical health. 94% said it was stressful and it made them anxious, which you can understand. A bit lower down, 34% of dentists said, I considered leaving the profession because of the effect of being investigated by the GDC. That is an incredible number. That's what it can do to you. A bit lower down, 72% of dentists, more than 2 out of 3, were fearful of being sued. 85% of them said it impacted upon their stress and anxiety. 65%, 2 out of 3, said it had an impact on their morale. The BDA's well-being research said, dentists aren't as happy as they used to be. So I thought I'd give you 6 quotes, all different people. We're expected to jump through more and more hoops, set at higher and higher levels, and yet whatever we do, it'll never be enough. Some of these might resonate with you. The NHS always wants us to provide more treatment for more patients in less time and to a higher standard, but is never prepared to put any money on the table. The people who write these guidelines should try visiting the same galaxy as the rest of us and spend a few days working for a living. The GDC has lost touch with reality and with what is and isn't possible in general practice today. They're not in the real world. I love this next one. The CQC would not recognize the inside of a busy dental practice if they tripped over it, and they'd be held to pay if they did. And the GDC must be really worried about the lack of complaints if they need to go advertising for them. I think it resonates with a lot of people in the room, maybe. The impact is all the stuff I've just talked about, but it's also this defensive dentistry. So I think you've got a group of people who are more twitchy, more worried, more fearful about litigation and being sued and whatever, and yet there's a load of other people who are just completely gung-ho and they're disappearing off into the sunset, and I'm going to talk about both those groups of people. I'm aware of 3 dentists that topped themselves last year because they were being sued or being complained about or being investigated by the GDC. And one of them was a patient of mine who became a dentist, so I've known him pretty much all his life. So we're not talking about little stuff here. We're talking about quite serious stuff. So a few facts for you. UK dentists, and I would exclude Scotland from this because they don't have no-win, no-fee lawyers in Scotland. So our members, dental protection members in Scotland, we charge them a quarter of what you have to pay south of the border, because there's not all the litigation and stuff. So they pay roughly a quarter of the English rate. And the UK dentists are sued more than dentists anywhere in the world, more than America, much more than America, 3 times more than New York and Florida, 2.5 times more than California. So, this is the epicenter of litigation. You're also more likely to be hauled up before your regulator if you do the same dentistry in Northern Ireland, which is part of the UK. You are 35 times more likely for the same dentistry to be looked at by your regulator than you would do if you were south of the border, answerable to the Irish Dental Council. So 35 times more likely, which is pretty spooky. And there's no other regulator anywhere in the world that investigates more dentists as a proportion than the GDC does. We also have more complaints than any other health professionals in the UK, which is very strange. But money changes hands. I think it's a huge factor. When you go and see a medical GP, you don't pay any money, but you do when you go and see a dentist. This diagram is a scary one. On the left-hand side, I said the GDC was supine, but on the left-hand side, when I first came into the medical legal field, 22 days a year took care of all the hearings of the GDC in a year. 22 days was it, total. By 2011, that had gone up to 640 days a year from 22. And in the middle, I've shown you that that was the year when the Dentist Act changed, so that clearly was a huge factor. By 2011, it had gone up, I talked about 2011, by 2013, it had gone up to about 1,000 days a year. And by 2015, you're going to say, oh, it was getting better. Unfortunately, that was only the first half of the year. I also have the second half of the year to share with you, and I asked what the ceiling height of this room was, and I realized that I couldn't fit the red bar in, so I had to show the two halves side by side. So that's the scale of what's happened, and if it feels like that, that is the reality of what we've had. The other thing is you've got, CQC, you've got the British media, never short of a voracious story about professional people, doctors and dentists, whatever. So it begs a question, doesn't it? Are we actually worse than everybody else? Are we 35 times worse than Ireland or whatever? And are we getting worse every year? Because that's what the statistics seem to say, and I absolutely think we're not. I think the factors are on the screen. No win, no fee. Shipman led all the healthcare regulators to be much more aggressive, much more robust. They're fearful of letting somebody slip through their net. So they're all outdoing each other, showing them what big muscles they've got. Look how we'll show you what we do to our doctors, or we do much more than that to the dentists. You watch us. And they have a regulator called the Professional Standards Authority, who give them a good kicking if they aren't robust enough. So the whole climate is designed in, and then we make major stuff-ups like mid-staffs and issues like that, which bring the healthcare profession into even more disrepute. And so it adds to the scrutiny. Every time I hear one of these crises, I think, oh, God, how are they going to react to this? What are we going to get now? Because whatever happens on the medical side always seems to cascade through to the dental side, even though it isn't us. We weren't mid-staffs, but we felt the backwind from mid-staffs, even though it was nothing to do with us. So we then look across the GDC, and there's the former Registrar Evelyn Gilvary and Bill Moyes sitting in front of the Common Select Committee. Don't know quite why Bill Moyes has got his hand over his mouth, but he should do it more often. This is what Bill Moyes had to say at the Pendlebury address at the FGDP 2 years ago. The exposure of failure will grow. The number of complaints about UK dentists is staggeringly high. It undermines the proposition that patients are happy with their dentist, which I think is an incredible thing to say. Bear in mind the GDC doesn't aggressively market its disciplinary role. We don't behave like a claims management company. Well, I'm afraid you do, Bill. On the left is an advert for a no-win, no-fee law firm, and on the right is the GDC's advert for complaints 2 years ago, and spot the difference. What we're in, therefore, is a different world with different kinds of patient. When they're not happy, they want to say so. In this country, nothing ever just happens anymore. It always has to be somebody to blame, and there needs to be some compensation for it somewhere in the system, and that everyone's sort of running towards that. And I think it is fueled by the media and by other parties, law firms, patient agencies sometimes. But I think we do a bit of it ourselves. What we see at the GDC, an awful lot more complaints now are one dentist potting another complaint, another dentist. We weren't seeing very much of that 20 years ago, but we see a lot of it today. And of course, things cost more, and during an economic downturn, you always get more litigation. In every country that has a downturn, you see that effect. Good news, briefly, LASPO is a change in the law in April 2013, Legal Aid, Sentencing and Punishment of Offenders Act, and that fundamentally changes the no-win, no-fee model. In the old days, the defense organizations had to pay what's called the success fee, which is very loosely a doubling of the lawyer's fees if they win, and now the patient has to pay that out of their winnings. So on a relatively small claim, the patient thinks twice before they sue, because they're going to give all their money away to the lawyer. And indeed, they start asking the lawyer the question about how much are you going to charge. In the old days, they didn't care too much. So that's been very helpful, but unfortunately, there was a long notice period from 2011, and the law firms, who are very entrepreneurial, got 2 years' notice it was coming, pretty much. So they were able to stockpile cases that they could run under the old rules in their cupboards, and we're only just emerging from that spike, that tsunami of old cases. And coming out the other end, more of the cases we're managing today are new cases under the new rules. So when, in a year or so, we come through to settle those, they will be settling at a lower level because they're under the new rules, not the old ones. So there is a glimmer of hope there. GDC Fitness to Practice was completely hijacked as yet another complaints mechanism. It was nothing to do with professional conduct that some of these cases were about. So the GDC, the annual retention fee, whatever, is now under huge pressure to sort out fitness to practice. And so even if you sit there and do nothing differently, the chances of you being dragged to a hearing are going down almost by the month, because the GDC cannot afford to run those hearings without sticking the retention fee up again. And after the meltdown we had 2 years ago, they don't want that again. And they would probably, if they froze last year, they would have to go to the Privy Council this September if they want another rise in the annual retention fee. And I think they're working very hard to avoid that. So both of those two things are good news. So there's never been a better time to have the best in-house complaint system you've ever had in your practice. So really work at that, because if you can mop up any dissatisfaction within the four walls of your practice, then it doesn't go to either of these two places. And the problem is that's where all the pain starts, and that's also why people end up paying more indemnity costs. So enough of the past and the present. Let's have a look at what's coming. Usually people say, I'm not going to go to that one because Kevin Lewis is always very depressing. So I promise you there's some laughter pills buried in the middle of the rest of my lecture. There's small ones. First of all, the big picture. I think we have to understand that I said the world has changed. I think what's coming towards us is a different bunch of patients. And there are some dentists who can see things more clearly than others. The George Bush famous picture with the lens cap still on his binoculars is probably one of the classics of all time. But I think if you're a dentist practicing, you have to understand that if I'm going to do complicated dentistry in the UK, which is the most litigious country in the world, with the most hostile regulator in the world, I had better be quite good at my risk management. Otherwise, I'm asking for it, and my records had better be pretty good. And the problem is in the UK that quite a number of dentists who come to the UK have come from countries where there isn't a lot of litigation. They haven't got a GDC anything like our GDC, and so it comes as a terrible shock when you do the same dentistry in the UK, and the consequences are very different. And I think that's a real issue, which we haven't really sort of addressed and come to terms with. So we've got a shrinking world. People are moving around more. Patients are moving around more. We've got a very consumerist country. Costs have gone up, both private and NHS. There's a lot of volatility. We've got Brexit and uncertainty in the air. Walk around that exhibition. What you can buy and do dentistry with is very different to what it was like 20 years ago. People are excited by and attracted to new technology, but every piece of new kit you buy has different risks. So you have to understand those risks. If you're going to start using that stuff, you have to not just look at what I can do with it, but also what do I need to think differently in order to keep myself safe while I do this stuff. The other big change, I think, is the digital revolution, both in terms of marketing your practice. A lot of people in this conference and in every other conference are, at least to some extent, looking at, will I be able to use this? Will my patients pay me the money to do this procedure or whatever? And the generation coming up towards us is very different. When I graduated, most people chose their dentist on the back of a personal recommendation from another patient. I'm an old-fashioned boy, and I think that's still how most people choose their dentist, on a recommendation from another patient. But people aren't buying anything else in their life that way. They're buying it through search engines. And the more we commoditize dentistry, the more we allow people to go on the internet and compare an endo here versus an endo there, I think it's very dangerous territory, because patients will be choosing a dentist not because they've been recommended to them, but because they got the best website, because they can talk themselves up better than the guy down the road. So we could end up with dentistry being done mostly by the people that can sell it, but they can't do it. And that would be dangerous for everybody, because that isn't going to help the litigation and complaints that we've got in the country. And what the GDC does and what the solicitors do and what the law does is always driven by the worst common denominator. It's when you get a Shipman, you get the reaction that we got from Shipman. So, we all need to be worried about dentists who are doing stuff beyond their competency. The other thing about generational issues is this is the group of people who will be having the children of, in about 2 or 3 years, 4 years, that lot will be the new parents. Here's a group of young university students having a conversation. They're actually texting each other. When I was a boy, we'd have sat down having a coffee together and we'd have talked to each other, but now we text each other because it's so much better, isn't it? Interesting generation coming towards us is, they'll never have a blind date because they'll look up the opposition on Facebook before they meet them. They'll never get lost ever again because they'll have their phone in their hand. They exist on somebody's hard drive before they're even born, like this one. It's a very spooky prospect as a grandparent of 2. Let's give you a brief respite for a second.
Ow! It's the final countdown! Will you just shut up for 5 minutes, please?
Yeah.
Thank you.
Yeah.
If you don't shut up, I swear! God, just wait until we get out of here.
That's the intermission. Back to the day job. Consent. Consent is one of the biggest things I think we have to understand has changed. As some of you in the room will know what the Montgomery case was earlier this year, or just over a year ago rather. Around the world, we've moved. In the old days, medical paternalism meant that doctors and dentists pretty much took the decisions for patients. The doctor knows best. And over the years, the world has changed much more to patient autonomy and giving the patient the right to choose. And as time passes, the direction of travel is definitely upwards and to the right. And we are one of the leading countries in the world in terms of that movement. We're up in the top right-hand corner already. But some people in other countries who perhaps come and practice here will find that very strange, because in some countries, it's still very much doctor knows best. So if you practice in the UK, you have to get that this is where we are in the UK. I'm only going to talk about one aspect of consent, which is the information you have to give patients. This is Sydney Harbour Bridge. And those of you who climbed up it will know, to start with, it's quite easy, but it gets steeper the further you go up it. And Australia led the way in terms of the change in consent. Some of you remember the Bolam test here in the UK. And the Bolam case in the late 50s was that if you do that which a reasonable body of your peers did, then you're not negligent. So you're measured against a reasonable standard that a reasonable body of your peers would think is reasonable. Halfway up the bridge, you've got a slightly different standard, and this is the one, it isn't do what a reasonable body of your peers would have done, it's a subtly different one, which is do that which the reasonable patient would expect you to do. And this was born in Canada. The first big case that took that view was in Canada. And so you're measured more by what the patient would expect of you than what another colleague would do. And then the very steep part of the bridge up on the right-hand side there is you've got to do that which not just a reasonable patient would expect you to do, but this particular patient you have in front of you would expect you to do. And in terms of consent, that means on the left with the Bolam standard, you give the warnings and information that a reasonable body of your peers would give, and that's your defense. Halfway up is you give the warnings that a reasonable patient would expect. And on the right-hand side, you give the warnings and information that this particular patient you have in front of you today wants, needs, and would expect. And needs in terms of, I need that information to make a decision, because without it, I can't really make a decision. But how many of us know each of our patients well enough to be absolutely sure about that right-hand one? You know, how can you possibly know what's the important stuff a patient needs to be given? Because in my world, if you give 999 warnings, their lawyers will swear blind that if only you'd been given the 1,000th one, that's the one that would have made the difference. So it's a very high bar indeed on that right-hand side. So it all happened really in the 1992-93. In Australia, they had a case called Rogers and Whittaker, and in Canada, they had a case called Ciarello and Schachter. And it really stopped everyone in their tracks. In the Australian case, Rogers and Whittaker, it said you have to warn patients about any material risks of the treatment you're going to provide. And that is defined as, in the circumstances of a particular case, number one, a reasonable person in the patient's position, if warned of that risk, would attach significance to it. So that's a bit like that middle stage on the bridge, isn't it? What a reasonable patient would expect. But secondly, if the practitioner is or should reasonably be aware that this particular patient, if warned of that risk, would be likely to attach significance to it. So you've gone to the top point in the bridge. And so Australia took us to the high point of the bridge in 1992, which was pretty scary because we were still with Bolam in 1992. We had two more cases. Rosenberg-Percival was a case of mine, which we took to the High Court in Australia and won, and that sort of brought a bit of common sense back into it, because that Rogers and Whittaker set a very high bar. You've got to know a lot about a patient in order to know what they would attach significance to, which you can't do on a new patient, that's for sure. And specialists could never get consent because all their patients are new patients, referred to them for the first time. So buoyed by the success of Rosenberg and Percival, we took another case to the High Court. I won't bother with that. Called Joaquin Paterno, and we came second. So that was very sad. In fact, I think it's fair to say we came third. It was a bit of a stuffing. In Ireland, in 1992, when while all this was going on, the court in the big case couldn't agree whether to do the bottom of the bridge standard or the halfway up standard. And 2 months apart in the same year, one Irish court went for the Bolam bottom of the bridge standard, and another court went to the middle one. So in one country, you had two completely different results. And then we had another of our cases at Dental Protection, which we took to the High Court, and it went further than the Bolam, the bottom of the bridge, and it rejected that, but it went further than the middle of the bridge too. It nudged up towards the Australian result. So the UK has been very behind the game. Australia had got there, Canada had got there, Ireland had got there, and the UK was still clinging to this, if you give the warnings that a reasonable colleague would give, you're all right. And the rest of the world was somewhere else altogether. And in the Geoghegan-Harris case, they said you must warn about material risks, and you particularly must warn when you're carrying out elective procedures, and you must warn of a known complication, and you only get out is if it's a very rare risk. Unfortunately, the court didn't define any of those things. So having given that judgment, everyone had to guess what they meant by that judgment. But I won't bore you with that. A clinician has a professional duty to warn a patient of all risks, including those risks of which he's unaware. Think about that for a moment. But this is Ireland. I'll just leave you with that thought. So in England, we had a whole load of consent cases. I'm not going to go through them, but they moved from that Bolam in stages, like death by 1,000 cuts, to a situation where a case, I'm not going to give you the details of it, called Chester and Afshar, was unbelievable outcome, which was a case in which 2 consent forms had been signed and witnessed, and the court found that the patient hadn't given their consent because the clinician had been too reassuring of the patient. that the patient thought, well, he's very reassuring, he's obviously not too much to worry about here. So even though 2 consent forms gave the warnings, the court said, no, it wasn't a valid consent. And so we all thought, well, we're buggered. We might as well go home. How many, do you need 6 consent forms? Is that what you need, So Montgomery, which was last year's case, it was a Scottish case, but it has application across the whole of the UK. In your handout, I've given you a reference on our website, so you can get an advice booklet explaining Montgomery and the other stuff I've just talked about. But very briefly, because it's a Supreme Court decision, it works through the whole of the UK, and it means the old Bolam, reasonable warnings the reasonable colleague would have given is gone. Hunter and Hanley is a Scottish case, so it means that's gone too. It shifts the requirement away from the reasonable clinician to the reasonable patient. Most people think it's stopped in the middle of the bridge. I don't. I think it's gone to the top of the bridge. For a patient who's got no special circumstances, your average patient, then what Montgomery has done is said you must give the warnings that an average patient needs. If perchance you're treating someone who's got a very specific need, if you're taking out a third molar for somebody that reads the news or is a musician, that patient clearly isn't an ordinary patient. That one needs a very different warning to the other patients. You understand what I'm saying? You've got to be much more like the top of the bridge. And I think the next case will take us to the top of Sydney Harbour Bridge in terms of the onus upon us to get consent. I think this is the hottest topic in medico-legal at the moment. So rather than give you something short in the handout, I'm referring you to a much more detailed source so you get this right. I'm not going to say any more on that. The last 3 are very quick. Quality and standards, this is the stuff I did in the BDJ. Everybody wants quality. Everyone talks about quality. Everyone's producing guidelines for us, but I think we have been asleep because what has been created for us is the ultimate in unlevel playing fields. If you look at a pyramid between unacceptable at the bottom, that red line is the junction between what's acceptable and what's not acceptable. Right up at the top is perfection. Most of us would like to think probably we spend most of our time in the desirable box, would we not? Straying into perfection occasionally, straying into acceptable occasionally, and hopefully not spending too much time below the red line. That blue indicator there is Bolam. It's that reasonable standard that a reasonable body of your peers would consider acceptable. So that reasonable standard is that red line. And the GDC is not allowed to interfere with your registration unless you've fallen seriously below a reasonable standard that your peers would find acceptable. You can't be struck off just for falling slightly below. You must have fallen seriously below. That's the law. So, and that's called misconduct, and that's where the GDC holds its hearings in relation to. But it's mild from what most of us would like to be doing day by day. Let's call that the minimum reasonable standard. Every one of you, back in your practice, has got guidelines, HTM 10105, NICE guidelines, this guidelines, faculty guidelines, college guidelines, whatever. The whole point of guidelines is most of them are aspirational. They're not describing Bolam. They're not describing the blue line. They're describing something better than the blue line. There's something roughly where I've put that green arrow. And the problem is experts in courts of law and at GDC are quoting from those guidelines, which are intended to be that green position, and by falling slightly below it, the GDC is coming to the conclusion it must be misconduct. Do you understand? We have moved the bar north, and we didn't even realize we'd done it. We have agreed, and we all want standards that drive us north, but rather like that famous line in Zulu where they said, "They're coming this way, sir," and there's thousands of them. That's how I feel about guidelines. There's thousands of them, and they're all coming towards us. So once you get to the position where that is mistakenly believed to be Bolam, then defense organizations are in deep doo-doo, because how do you defend something when the world is saying that that's Bolam? It's not Bolam. We've got to shout and scream and kick and persuade experts to admit it's not Bolam, because otherwise that lot is indefensible, in courts of law. And what we're trying to do is fight back a little bit against that. And if that red line is this mistaken idea of Bolam, then that black line is GDC's mistaken idea of misconduct. And in actual fact, people have been found guilty of misconduct for stuff which you and I would be considering perfectly reasonable. And this is, I think, the reason why. The other thing about the GDC is there are lay and professional people who look at the same events differently, but now there is always a lay majority. That's the important thing to remember, is it's a lay majority, and you're no longer likely to be judged by your peers, because in many cases there's an implant case or an orthodontic case, but the people hearing it have never placed an implant in their life or have never done any orthodontics in their life, and yet they are the only dentist on the committee which is going to hear it. And I just think it's an accident waiting to happen. I'd like to just say a quick word of congratulations to the FGDP, the faculty. They've just, 2 weeks ago, issued their new record-keeping guidelines, and lots of discussions between us and the FGDP. And now when they list what you need to find in a record card, they actually indicate whether this is the minimum standard or whether it's aspirational or whether it's desirable or whatever. So each separate guideline is now indicated. It's kite marked, so you can't misinterpret it. And you can't be beaten over the head with a guideline that's not intended for the purpose. So well done to FGDP. That's a good bit of work. A few words on competence. Is being good good enough? I don't think it is anymore. I don't think being extremely good is good enough anymore. And I think the reason for that is it isn't just the dentistry. I think when you do dentistry, you may be competent to do a root canal, perhaps not as competent as Pierre, but you may say, oh, I can do molar root canals. I've done those. But whether or not you're safe to do it today depends on a whole shed load of other things. And some of them are clinical, but many of them are non-clinical. I always think it's like a sort of mother of all Rubik's Cubes, where all these risks are layered one on each other. And the number of combinations are endless. This is the grandmother of all Rubik's Cubes. And when you scratch the surface of somebody who suddenly has a cluster of cases, very often you find it's nothing to do with their dentistry, but something's going on in their life. They've got a divorce, or they've got money worries, or a partnership dispute, or something like that, or they're not well, or they're on the booze, or there's something happening. There's something's happened in their career. It sometimes is the practice they're in and the support they get in that practice. And I do worry about young dentists in some corporate environments, because what comes down the phone to us is very, very scary. Those of you who work in the NHS, I think I've heard a new record last week as a dentist in one of the corporates who's being paid £5.75 a UDA, which I think it means they're getting less than 20 quid for a molar root canal. So I think Pierre might have a view on that. And then you've got layered on that, which tooth you're treating, what technique you're doing. Very often, which patient are you treating? Because with some of our patients, we've put enough points on the board with them that if something goes wrong, they'll forgive us for that. And it's much more risky to treat new patients, patients you don't know very well, patients you haven't got a credit bank with. So I think it's very different. I do believe we're all one patient away from the biggest triumph or disaster we've ever had, career-shaping moments. And I always think Johnny Wilkinson back in the Rugby World Cup, he was seconds away from either being a hero and being on TV forever, or being that prick that lost us the World Cup back in 1990. It was going to be one or the other, wasn't it? And it was all going to be over in a couple of seconds. And Chris Robshaw, my wife is Welsh, from a Welsh rugby family, so we do have views on the decision that Chris Robshaw took when we were playing the Wales in the World Cup last year. Bugger. I read a lot of stuff, and I've put this in your handouts for you. Malcolm Gladwell is the guy that wrote Blink. He also wrote a book called Outliers, and it's a brief word on competence. You can't get excellent quickly. There's no shortcut. You have to put the work in. And he talked about the 10,000-hour rule. You have to put in the hours and work purposefully and whatever. Matthew Syed described a nice phrase, purposeful practice is when you don't just put the hours in, but you make every one of those hours count. So you're learning and learning again and learning again. And mentoring comes into that. And what Syed's different from Gladwell was that Syed said, just being talented isn't you don't have to be that talented. If you're reasonably talented and you put the hours in, you can be as good as the guy that's richly talented but doesn't put the hours in. And that's hopeful for us all. So getting towards the end, Chris, are we good for time? We got a few minutes? 2 or 3, a few minutes, okay. But I'll keep it 3, 4, something like that. We all start from a position of unconscious incompetence. We don't realize we're not good at stuff. Some people within that group think they're bloody marvelous. They look in the mirror and see Brad Pitt. I mean, I do it every morning. You know, I just get terrible disappointment when people don't call me Brad when they bump into me. You move from that position to a position of conscious incompetence. Suddenly, you come face to face with failure, and you say, actually, I'm not as good as this I thought I was. You know, now I've seen the X-ray of that root canal. Perhaps it isn't as special as I thought it was. Then you work on it, and you become consciously competent. You gradually work out what you're good at and what you're not good at. And when you get really good, like Pierre, you end up unconsciously competent. Pierre probably can't remember why he's so good at this stuff, because he's just done so many hours and he's worked so hard at it. He just does it. It's like the golf swing or the tennis serve or something like that. It just happens. What we forget is, and I remember a very famous case in, I think it was in New Zealand, where one of the doyens of a subject just started a new technique, and he thought, well, how difficult can this be? I'm brilliant at what I do. And he forgot that he's a student again. He was starting a brand new circle. He was unconsciously incompetent at a technique he'd never done before, even though he was brilliant at everything else he did. So it was that humility to realize that we all spend our whole career becoming students again, and we have to go around that circle. So those of you who want the simpler version of this, it's on the left. And it does remind me of the little boy who he thinks he's got the best in the world because he's never compared it to anybody else. It's very easy to impress yourself when that's all you've ever seen. A bit of peer review is never a bad thing, I think. So I will finish on a lovely, well, almost finished. There's one little line after this. But in a playground, this little girl is talking to the lad, and the lad says, take a look at this. Is that impressive or what? Don't you think that's good? And she said, what have you got there? So he showed her, and she said, what the hell is that? And he said, well, I've always had it. She said, well, I've not got one. He said, well, you must have. All my mates have got one. So he has a look, and he says, well, I can see where it used to be. It's obviously broken off. Have you left it anywhere? Have you lent it to anybody? All that sort of stuff. Anyway, she's in tears. She runs home, talks to her mum that night, and the next day in the playground, he says, oi, Sandra, over here, God, look, it's looking even better today. Come and have a look at this. And she says, I'll take it or leave it, really. And he says, well, aren't you jealous? She said, no, I'm not. And he says, well, you must be jealous. I mean, why aren't you jealous? And she says, I was talking to my mum last night, and she says, as long as I've got one of these, I can get one of those any day I want one. It's a good story, isn't it? And you get CPD for it as well, which I think is excellent. So, if an opportunity, I mean, my final plea is, let's stay within our competence. Let's not add to the tsunami of litigation. Let's work out what we're good at and what we're not. If an opportunity for the acquisition of knowledge and skill appears to be too quick and easy to be true, it probably is too quick and easy to be true. Question the quality of the people at whose feet you sit. In Australia, when you go on a course and you reckon you start doing something because of that course, you will be asked, what due diligence did you do on the speaker at that course to satisfy yourself that that speaker was fit to give you the training you needed to go out and do this stuff? It's a very interesting shift of the obligation. There aren't any shortcuts. There's no substitute for the investment of time and money. And I love this. On the road to success, there are no shortcuts. And if you look at the back of the van, it says our most valuable resource sits 63 feet ahead. Not anymore, he doesn't. I think you'll find. So that's a quick skirt through Dentolegal challenges. I hope I've given you some pointers, some food for thought, whatever. Chris, thank you for the invitation and for the introduction. And I hope you have a good rest of the day. Thank you.